Hello, everybody. I'm Ross Birkbeck.
And I'm Shane O'Driscoll.
And we're from Multiple Tax Chambers. Welcome to this edition of TaxSnax, where we're going to be looking at discovery assessments because they're always important when you're dealing with HMRC, and because either one certainly have issues with discovery assessments coming up regularly. I'll start off by saying we're going to be looking at discovery assessments in the context of personal tax. The rules for corporation tax are broadly the same, and a lot of what we're saying applies equally to corporation tax. But obviously, if you're looking at VAT or some of the other taxes, etc., the rules are different. So we're looking today at personal tax, and yeah, everything to do with discovery assessments.
So just to level set, I suppose I'll go into what discovery assessment are. So HMRC have the power to reopen a past assessment if they discover an underassessment that results in the loss of tax. Discovery assessments are important because they are HMRC's only opportunity to recover underpaid tax once the normal self-assessment inquiry period has expired. So when the time limit for opening an inquiry expires or an inquiry is closed, typically the taxpayer's liability for the relevant tax year at that stage is generally regarded as final. But in these circumstances, HMRC can demand a further tax payment by raising a discovery assessment. So there are a few conditions which are required for raising a discovery assessment. So I suppose the primary one is the tax loss condition. So an incomplete disclosure which is leading to a tax loss, and that could be a loss due to insufficient tax paid, or the relief applied was in excess of what was actually supposed to be applied, or the income tax itself is not being correctly assessed because something was left off the return. And then the other conditions that need to be there, so either the conduct condition or the officer condition. So the officer condition is an inquiry for a tax period is closed, and the hypothetical officer could not have been reasonably expected on the basis of the information made available to them to be aware of the facts leading to the potential loss of disclosure. Or the other one, which is probably more common, is the conduct condition. So that's where HMRC must show that the loss of tax is attributable to the careless or deliberate behavior of the taxpayer or a related person. Typically, that is somebody who's acting on the taxpayer's behalf.
Yeah. I think this is why probably we'll assessments are the most commonly disputed form of tax, liability, because it's the situations where the revenue are accusing you often of being careless or deliberate, or of not telling them everything they needed for their in your return, and which is why I think they're so often contentious. And they often start on that foot too of contentious tax rather than an average inquiry where you're in a normal inquiry process or something like that, where it can be quite cooperative.
Yes, and indeed the time limits are extended then depending on the type of behavior that is being alleged of the taxpayer. So careless type error would be 6 years from the end of the relevant accounting period, whereas a deliberate error would be 20 years from the end of the relevant period.
Yes.
And there is certain discussion around staleness, and I believe you're involved in a few cases in this area.
Staleness, the tooth case. Well, I think we'll come to yes, tooth.
Might be a good place to lead into tooth.
Yeah, although just before we do, of course, 20 years also applies if you don't submit a return at all.
Correct,
so if you fail to submit a return, it doesn't matter whether carelessly or deliberately, and that also gives HMRC 20 years. But yeah, staleness is it has been a concept that's been around for some time and is now on its way out, it seems. This was an idea floated in some tax appeals that discovery, once the revenue make a discovery, it could go stale. If they didn't act on it within a sufficient period of time, it would sort of run out of being, it wouldn't no longer be a new discovery that would justify an assessment. There's an interesting parallel there to the VAT rules, where HMRC, under the legislation, expressly had 1 year to act on a discovery. And that was sort of imported in the case law, in a case called Charlton, and picked up in this case called Tooth, where the Court of Appeal sort of affirmed the concept of staleness. What then happened, after a lot of people relied on this concept and appealed their assessments on the basis that they were stale, the discovery was stale, was that the Supreme Court reversed that decision, and it said what a lot of people have been arguing actually throughout, was there's no concept of staleness in the legislation. There's no reason to import it. The time limits are the statutory time limits, and there's not any other type of time requirement. What we've seen now, well, I've been involved in a case called Harrison, along with Harry Brown, our chambers as well. A case in the other tribunal came up just the other week, where the argument was that although the Supreme Court had said very clearly that staleness isn't a thing, it said it obiter, which means it wasn't part of the actual ratio, the rationale for the decision. And under the laws of precedent, that's basically not binding. Whereas the Court of Appeal, which the Supreme Court had said was wrong, that decision remains the law. So this was an argument that's been tried in a number of cases recently. The upper tribunal didn't like it at all, and they say the Supreme Court decision must be followed. And we'll see what happens with that if it does go to appeal, whether that will finally settle the matter. But it's concept of staleness, not currently something you want to rely on unless you're in a very tight corner, and probably very much on its way out, one way or another.
So it's not a very satisfactory position for a taxpayer at the moment. It's not certain. The whole point of the limitation period would be to draw a line under your liability and move on, hopefully. But
indeed,
if I understand correctly, we're in a bit of a grey area around.
We're in one of those where there's a technical legal battle about whether or not, what one case says versus another. I think from a practical point of view, certainly the HMRC are happy that staleness as a concept is gone, and it's no longer a proper way to defend yourself against an assessment.
So using a concrete example, if a HMRC officer forms a view and has a discovery at a particular time, and they're at the borderline of the 4-year period, for example, but then don't issue the letter and subsequent for some time afterwards, that's where that sort of argument would arise, or does it
no,
arise?
that's a slightly different issue. And actually, I've got a case going on this at the moment where what happened was HMRC issued their discovery assessment on the 2nd of April, so 2 days, or no, they didn't issue their assessment. They claim they made the assessment 2 days before the deadline, but they didn't tell the taxpayer about it for another 3 months until June. So June comes around, the taxpayer receives a notice saying you've been assessed to this tax, and quite sensibly thinks you're out of time. Sorry, the deadline was 6th of April. Which there's a couple of interesting points about that. The first is that the burden is on HMRC to prove that they made an assessment and when. So they've got to prove evidence of the assessment they made it if you challenge it. But the second is actually that there's telling you about the assessment is not making the assessment. And the case law is fairly settled now, that actually HMRC can enter the assessment to your tax at just before in time. They don't need to tell you about it within any set period, which is odd and rather unsatisfactory. A query, obviously, if they left it for too long, there might be a grand judicial review you can bring out against them if your circumstances change or something like that. But there's nothing in the tax legislation that says they have to give you the letter actually charging you for the tax, or telling you about the charge you've already got in any period at all. The time limits for appealing start from the date of the notice, so it doesn't create any sort of necessary unfairness there. But it does appear to undermine the whole concept of the certainty of the 4-year period or the 6-year period. You hit that gap, you haven't got a letter from HMRC after 4 years or 6 years, and you think, right, that tax year is now settled. Well, there's always the chance you have a letter telling you about something much later, which is not good. Yes, that's an interesting issue. I think the other point about assessments and the burden of proof, and I think it shows in the Harrison case as well. One of the other points looked at there was that the burden's on HMRC to show that they made an assessment and that they made it in time. So they have to show the discovery, which obviously.
So is it a precondition to the action, or is it just, does it boil down to then just a pure burden of proof discussion? Or
I think the way it works is that sort of in tax law generally the responsibility to prove, if you make an appeal against HMRC or discover an assessment at all, discovery assessment, that the obligation is on the taxpayer to show the correct amount of tax. The rationale goes that, well, you're the taxpayer, you know your affairs, so you should have to prove how much tax is due. The revenue are allowed to come in and go, well, we say actually your assessment's wrong, your self-assessment's wrong. You know, whatever it is, that's a chunk of money because we say it's due, and it's your job to prove them wrong. And if you can't prove them wrong, their assessment stacks. But they have to first prove they met the conditions for discovery assessment. But
So it's a preliminary point they need to get over.
Yeah, so they have to get over that hump. And there's a case called Burgess, which is very established now, that says where they failed to do this. They failed in their statement of case to say they'd made a discovery, and when they made it, and when they issued the assessment. And at the appeal, it got to tribunal, and the taxpayer said, well, look, they've not shown they made a discovery at all or assessed us in time. You should, and the court agreed, and they won on that. But what you see now, ever since, is in every tax appeal, there's a section in the HMRC statement of case where they say, we made a discovery on this date, this is how it happened. Very rarely is it contentious.
Okay.
You know, mostly there's a dispute over an amount of tax due. So prima facie, HMRC discovered an amount of tax, they made a discovery, and that's what they're assessing you for. So it's very rarely disputed that they've made a discovery at all.
So, but then
there is this burden.
But then by them putting that in their statement of case, it's preempting a challenge.
Yeah, exactly.
On their feet where they have to sort of, where this.
Yeah, it kind of shifts the burden back to the tax. They've said this is our case on discovery and on the assessment, and it kind of shifts. And if the taxpayer wants to challenge it, they can, and they can push back on that. And you know, again, in Harrison, the argument in the upper tribunal was, well, they never pleaded it or evidenced it, and the first tier tribunal didn't find this as fact, but they made the discovery assessment in time, and the upper tribunal was like that. That's quite low.
I'm reluctant to ask a question that I don't know the answer to, but or maybe you can't answer it either. But what's the next step? How do we resolve this conundrum? Is it Harrison gets appealed? Is it going to be appealed to sort of bring a conclusion to whether the comments in 2 were obiter or should have been?
Yeah, I don't. I mean,
firm?
it could get appealed up to the Court of Appeal if the Court of Appeal decides it wants to resolve this question of precedent, because there is some law on when obiter findings of the higher court can impact, can overrule the ratio of a lower one, but it's not necessarily quite clear the scope of that and when that will apply, which was the discussion in Harrison. Court of Appeal might think it wants to clarify that. And it might also want to overrule itself based on the Supreme Court decision in its previous in the 2 case. So that would certainly put to bed the staleness thing. It might just be the other way this goes is the courts will just decide no, look, we agree with the upper tribunal in house, and this is all done and dusted now. You can carry on.
So for the foreseeable future, there's still potentially a point of
a very
plucky
taxpayer with his back to the wall could, I suppose, take it again. Yeah, if we don't go any further. Well, hopefully that's an interesting, if scattergun, little chat about discovery assessments. Thanks for watching.
Thank you.